Due process of law, or if you were arrested by Will Atkinson, Bennett, Liesl, and Marie McCoy. So if you were arrested, at the point of your arrest, you would be read your Miranda rights. This is the law because of the court case of Miranda versus Arizona. The police officer that arrests you may take away any of your personal property that you have and put it in a safe place until they finish performing inventory at the scene of the arrest. After this, you have the right to make a call or several calls depending on the circumstances once you're placed under arrest. The next step is booking. The police officer will ask for your basic information, like your address or your birthday. They'll fingerprint and photograph you. You may be asked to participate in a lineup, give a handwriting sample, or do other similar things. And if you're detained but not booked within a reasonable period of time, your attorney may go to a judge and obtain a writ of habeas corpus. Next is a preliminary hearing. This is when a judge decides if there is enough evidence in a case for further proceedings, like a trial, to occur. One judge listens to arguments from prosecution and defense, just like in a regular trial, and then makes a decision about whether the case will go to an actual trial. Next is the arraignment. This is a formal reading of the criminal charging document in the presence of the defendant to inform them of the charges that have been placed against them. The judge reads the charges, asks if the defendant has or needs an attorney, asks how the defendant pleads to the charges, and announces the dates of any future proceedings. Next is the pretrial. To avoid trial and/or long sentences, the vast majority of criminal cases are settled with plea bargains between the attorneys independent of a judge. The defendant and the prosecutor negotiate a deal for the defendant to plead guilty and get something in return from the prosecution. Fun fact, this was established as constitutional in Brady v. U.S. in 1970. But if no plea bargain occurs, the actual trial occurs. During the trial, the judge will preside while the defense and prosecuting attorneys present evidence and represent their client. They also call witnesses, and the defendant has the opportunity to testify before the judge and an impartial jury that comes from wherever the crime was committed, and there are usually 12 jurors. After the trial is over, there will be a verdict. The verdict is read after the jury notifies the bailiff, who then notifies the judge that the decision is ready. The verdict will be guilty or not guilty, and the trial ends after this decision has been read by the judge. After the trial is over, an appeals process may occur. In a civil case, either party can appeal. In a criminal case, only the defendant can appeal. The person seeking to appeal the case at the state level must obtain a rights of appeal. At the federal level, they must obtain a writ of habeas corpus. If either of these things is obtained, the case is then sent to an appellate court. If the appellate court agrees with the decision of the lower court, nothing happens. But if the appellate court disagrees with the decision of the lower court, the case is then sent back to the lower court. At this point, the lower court can hold a new trial, reconsider facts, and all the while look to the appellate court ruling for guidance on what to do. So, now you know, if you're arrested, your rights in the due process of law